appeal in the matter of Kireeva and Bedzhamov.
Mr Davis.
Good morning, Lord. Lords, on these two appeals, 1509 and 1531, I appear with Mr. Wilson for Ms. Kireeva, who's the Russian bankruptcy trustee and financial manager of Mr. Bedzhamov, for whom my own friends Mr. Fennick and Mr. Robbins appear. Lords, in the broadest terms, the trustee appeals against the judge's decision that, having accorded formal recognition of the bankruptcy and the trustee's status as his trustee, the court has no power to assist her. On the other hand, Mr. Bedzhamov appeals against the judge's decision to recognise the bankruptcy and the trustee's status. Your Lordships will have seen that both appeals are brought with the permission of the judge. I think, and I hope, the court should have a core supplementary and additional bundle, and
yes.
4 bundles of authorities.
Yes.
My Lords, I've been asked to indicate that the transcribers, if at all possible, would welcome a break, a short break during the course of the morning. Obviously, I'm in your Lordship's hands on that.
Provided that you jointly think you can accommodate the breaks within the timetable, I'm quite happy.
Well, not I feel bound to allow them to have a break if they require one.
Yeah. In which case, somewhere around 11:45.
I'm obliged. Lords, the main issue on our appeal, I should have said, your Lordships also have a timetable, which
yes.
I hope has filtered through,
yes.
which obviously we will adhere to. The main issue on the trustee's appeal, which I'm now addressing, is whether the court, having given recognition at common law to a foreign bankruptcy order and also to the status of a foreign bankruptcy trustee, has any power to assist the foreign trustee to protect or control the bankrupt's English real property registered in his name in England. And if your Lordships could take out the judgment, which amongst other places is behind, I think, tab 7 in the core bundle. And if we're looking at the core bundle, I think it's page 137, paragraphs 251 to 252. In effect, in those paragraphs, 251 and 252, Mr Justice Snowden answered that question in the negative. And my Lord, staying in the core bundle, that is reflected in the order he made, against which these appeals come to you, behind tab 5, I'm so sorry, tab 6, page 81. Paragraph 1 is the order providing formal recognition to the trustee and of the bankruptcy order. That's the subject of my learned friend's appeal. And paragraph 3 is the subject of our appeal, whereby he dismissed our application insofar as it sought recognition in respect of the English real estate. As your Lordships will appreciate, we also appeal against paragraph 4, which is a discrete area of the judgment, which I'll come to in due course. Turning back to the judgment, for the purposes of the trustee's appeal, the relevant paragraphs containing both the reasoning and the disposition are paragraphs 195 where the judge begins under the subheading Immovable Property, the authorities, to look at immovables, all the way up to paragraph 268, where he, in those conclusory words, reaches his disposition to the effect there's no power to assist. Therefore, as your lordships will have seen, the judge did not go on to consider discretion which would have been at what the parties understood to be stage 2 at a subsequent hearing. As it were, we failed in limine at the first stage for the absence of a power to help. Your lordships will have seen that the main subject matter of the appeal is a property in Mayfair, known as 17 Belgrave Square. It's a slightly complicated title, which is irrelevant, and the judge describes that in paragraphs 56 and 57 of his judgment. Mr Bedzhamov asserts that that has a current market value of some £35 million sterling, and that it's charged as security for debts in excess of £40 million sterling, mainly to a BVI registered company called Clement Glory Limited, but also as to a first charge for £5 million in favour of Mishcon Derea, Mr Bedzhamov's solicitors. Security in favour of Clement Glory was granted by Mr Bedzhamov after he had secured an adjournment of the hearing of his Russian bankruptcy petitions. And it's our case that, in due course, if we're duly recognised, we wish to establish that that security is liable to and should be set aside. The security, on the other hand, held by Mishcon Derea, your lordships will have seen, was created by Mr Bedzhamov with permission of the court. Mrs Justice Falk gave that permission by her order dated the 5th of March of this year, at a time when the trustee's recognition application was still pending. The trustee applied to set aside that permission, and again on grounds that the court had no power to assist the trustee. By paragraph 4 of his order, as we just saw, Mr Justice Snowden dismissed that application without regard to the merits of it. And again, the trustee appeals against paragraph 4, and that is our discrete ground 6 of our grounds of appeal. Now, my lords, at the heart of the trustee's is the what we've dubbed or described as the Immovables Rule, which, for these purposes, is Dicey Rule 217. And it may be of assistance at this stage to have open 2 documents. First of all, the judgment itself, paragraph 206 on page 125 of the core bundle. But also in the 4th volume of the authorities at tab 81, I suggest it might be useful to see how this appears in Dicey. And that's quite a chunk of Dicey at tab 81, and I'd invite you to go to page 1757. And I'll start, if I may, with Dicey itself.
Sorry, which page did you say?
It's the 4th volume of authorities,
Yes.
tab 81, page 1757 of the text, which I hope is Rule 217.
Can you see it? Yeah, I see, yes. Yes, caught up.
And forgive me, I won't read all of this, but I will read the rules. Subject to the effect of the insolvency regulation, an assignment of a bankrupt's property to the representative of his creditors under the bankruptcy law of any country other than Scotland or Northern Ireland is not and does not operate as an assignment of any immovables of the bankrupt situate in England. But in a proper case, the English courts may authorise the appointment of a receiver of the rents and profits of such immovables. If I may, skipping the first paragraph, you'll notice that the second paragraph, starting according to the end over the page with the words "the same result," was reproduced by Mr Justice Snowden in paragraph 206 of his judgment. And the only reason for asking you to look at it as it appears in Dicey, and it may be that I'm being over anxious here, is just that your lordships can see how the footnotes work and the illustration at the end, which he doesn't reproduce. And so having in the second paragraph of the note reproduced in effect the Immovables Rule and the fact that it doesn't affect title. But Dicey then goes on to say a foreign trustee who would otherwise be met by the obstacle contained in this rule may be able to mitigate its effect if the English court in a proper case is prepared to appoint a receiver of the rents and profits of the immovables, and then authority for that is first Cooperman, and then a Scottish decision called Araya and Coghill. And for your Lordship's notes, in case it matters, you'll find Cooperman at tab 26 and Araya and Coghill at tab 25 of the authorities bundles. And then the note that Dicey continues, furthermore, the trustee may be able to invoke the provisions of 426 of the Insolvency Act, section 426 of the Insolvency Act 1986, with a view to achieving the same result. And we'll come back to those words, the same result, in due course. And then authority for that is, as far as cases are concerned, two cases, re Levy's trusts, you'll find that at tab 10, authorities bundle, re Osborne at tab 27. And you'll see that in the description in footnote 255 of re Osborne, it includes accurately, as you'd expect, the words appointment of receiver of rents and profits of English lands with authority to sell the same and retain the proceeds as trustee for the benefit of the creditors, but without prejudice to the rights of prior encumbrances. And as we'll see in due course, the order that was made in re Osborne was following the order in effect that was made by Mr Justice Asprey in re Cooperman. But I'll come back to that. So at this stage, that is the Immovables Rule, and your Lordships will see, going back to the judgment, that at paragraph 252 of his judgment, Mr Justice Snowden found, page 137 of the core bundle, 54 of the judgment, he said, in my judgment, the common law position in this respect is correctly stated in Rule 217 of Dicey and the note to it. To the extent that commentaries in Fletcher and Sheldon might be thought to state a wider proposition as to the availability of relief, it should be understood to be dealing with the type of orders that might be available to respond to a request under 426, not with the relief that is available at common law. That is his reasoning. It's a crucial reasoning and an essential reasoning, as we'll come to see, in deciding that the cut-off point is the ability or power to appoint a receiver over rents and profits, but no more. And he finds in terms that there is no power to do anything further than that, including to give such a receiver a power of sale or to take possession. And we get that from reading 252 followed by 251, where he finds that there's no power, quote, to make a vesting order or a personal order to transfer it to the trustee, or in some way conferring possession and control of the property on the trustee. And that's the ratio, in effect, of his decision. Now, the decision with respect to Mr Justice Snowden to, as it were, approve both Rule 217 as stated in Dicey and the notes or the narrative and text to it can't be surprising, because it was, amongst other things, approved by Lord Sumption in paragraph 12 of Singularis, although that's not referred to by Mr Justice Snowden. And so it's not controversial in this court that in this case, if it were otherwise thought to be appropriate, my clients could be appointed following recognition as a receiver of rents and profits over 17 Berkeley Square, but not with a power of sale.
So the bit that isn't controversial is that you could be appointed receiver of rents and profits.
That's the bit that's uncontroversial.
That's the bit that's uncontroversial.
Yes.
Yes. Yep. The power of sale bit is controversial.
Yes. Now, my Lord Sub, this conclusion, I think we're entitled to say, is at odds with all the leading textbooks. We've set those out in paragraphs 32, 3 of our skeleton argument. And it's at odds with powerful statements made in various of the trilogy of cases in the Supreme Court or Privy Council, namely Cambridge Gas, Rubin and Singularis. And again, we've given references for those and we will look at those in due course. But before analysing the judge's reasoning as to how he reached that conclusion, it is, I suggest, necessary to identify the modern explanation for the court's discretion to assist foreign office holders at all. And that's now encapsulated in the phrase modified universalism. And I don't think this is controversial either. That principle can be summarised as follows. So far as legally possible and subject to public policy and local law, assistance will be given by domestic courts to overseas office holders so as to achieve the same result as if there was one universal insolvency jurisdiction. And this isn't challenged by my friends, and indeed Mr Justice Snowden, in his own judgment, set out the ingredients of modified universalism by reference to the trilogy of cases. And it may be worth first just looking at page 228 of his judgment, where he cites or quotes from the speech of Lord Hoffman in Cambridge Gas, which is now a very familiar formulation, and this is the aspect of Cambridge Gas which survives and is still on any view good law. I just invite your lordships to remind yourselves of paragraphs 6 and 7 of Lord Hoffman there. Two small points, if I may, by reference to this. Could I just invite your lordships to look at the last line of paragraph 6 as quoted. Receives worldwide recognition and it should apply universally to all the bankrupts and then assets. So this appeal concerns the central function of any trustee anywhere in the world, as between itself and the insolvent entity, identifying and protecting the assets. And then at paragraph 230 of his judgment, Mr Justice Snowden cited from Lord Collins in Rubin, and at paragraph 29 of Lord Collins in Rubin, which he sets out at the foot of the page there, 131 of the core bundle, within paragraph 230, he states the principle by reference to African farms. And then a very influential passage from the judgment of Lord Justice Millett in Kuoji, which has been cited with approval time and time again. Could I invite your lordships to read that? So we're now within Lord Collins in Rubins, who is in turn citing Lord Justice Millett in the Credit Suisse and Kuoji case. And the particular words that I would commend your lordships within the passage from Lord Justice Millett are those words in the last 4 lines, but this should not inhibit a court in one jurisdiction from rendering whatever assistance it properly can to a court in another respect of assets located or persons resident within the territory of the former. And I won't weary you much longer with these quotations because they're all of in the same vein. But at 232, now in singularis, Mr Justice Snowden cites from Lord Sumption, in paragraph 15. And that phrase in the first sentence that he cites, the first is the principle of modified universalism, namely that the court has a common law power to assist foreign winding up proceedings so far as it properly can. And that is a phrase that crops up time and time again. And that's the first of the propositions that was established by Cambridge Gas. That remains good law and has been endorsed both in Rubin and in Singularis. And it's worth, now that we're there, carrying on to look at the second and third principles that were enunciated in Cambridge Gas, because they now have been, as it were, ditched and not followed. And the second and third principles are not something that Ms Kireeva, as trustee, needs to invoke, thankfully, and it is not something that we say is engaged at all on these appeals. But it is important to bear in mind that when one says that Cambridge Gas has been in some way discredited or diluted, it is those second and third principles that have certainly gone, and the first most emphatically remains. And finally on this, it had to happen at some stage. Could I ask you to turn to Singularis, which you'll find in the third volume of the authorities, in tab 64, I think. And within the judgment of Lord Mance, at paragraph 132, page 1723 of the report, 1723 of the report, paragraph 132. This was his dissenting judgment, but dissenting only in respect of the particular issue in that case about the exorbitant use of the common law to graft foreign legislation into an insolvency.
Which very much you started with?
Paragraph 132.
Thank you.
He opens by referring to African farms and the fact that it's been lost in what he would describe as unfair obscurity for some time. And could I invite you, after the reference to Helmuth James von Moltke, to look at the passage which reads as follows: the essence of the principle consists, as Lord Sumption notes, in the recognition by one court of the foreign liquidator's power of disposition over the company's assets in the domestic jurisdiction. That justified an order restraining their disposition or seizure inconsistently with the foreign liquidation. And we would respectfully suggest that is a good formulation of what is going on in relation to assets when one is looking at the application of the principle of modified universalism. We suggest that the primary function of the principle of modified universalism is indeed the protection of identifiable assets within the jurisdiction of the foreign court or local court, which is this court, for these purposes. And if one just very briefly goes back to Lord Collins in Rubin, which is in the previous tab, tab 63, and turns him up at paragraph 12. One will see that it is not a new concept in that in paragraph 12, Lord Collins cites from Lord Dunedin in the House of Lords in Galbraith and Quinn in respect of the universal process for the distribution of bankrupt property. Where such a process was pending elsewhere, the English court should not allow steps to be taken in its jurisdiction which would interfere with that process. And then he cites from Lord Dunedin. And at paragraph 14, at the foot of that page, Lord Collins emphasises, as so many judges and courts have, the way in which the world has changed. If the Lordship looks at the last 3 lines on that page, there's no doubt today international cooperation in cross-border insolvencies has become a pressing need. It's only necessary to recall the bankruptcies or liquidations of BCCI, Lehman, each with international businesses, assets in many countries, and potentially competing creditors. There is not only a need to balance all these interests, but also to provide swift and effective remedies to combat the use of cross-border transfers of assets to evade and to defraud creditors. And it's with that in mind that Lord Collins at 17 then refers, understandably with respect, to the change that the expression universalism has undergone since first used in the 19th century in the South African jurisprudence. Now, with that sort of canter through modified universalism having completed, may I now turn to section 426 of the Insolvency Act of 1986, because I think I would be an assistance to your lordships to hear my submissions on 426 before we look at Mr Justice Snowden's reasoning. I should have asked you to keep out Rubin if you've put it away, and I apologise if you have, because within Rubin, again Lord Collins, at paragraph 25 of his judgment, he identifies very usefully what he describes as the, quote, 4 main methods under English law for assisting insolvency proceedings in other jurisdictions. And the first of the ones that he lists is section 426. And he says it provides, quote, a statutory power to assist, this is paragraph 25, corporate as well as personal insolvency proceedings in countries specified in the Act. And as your lordships will have appreciated, the corporate aspect of this only came into, was only enacted with the 1986 Act. So prior to the 1986 Act, it was personal only. Turning then to Mr Justice Snowden's judgment, at paragraph 111, he set out the reasoning, the text of section 426. Insofar as relevant to the case before him. And your lordships will see at paragraph 111, he sets out paragraphs, subsections 4 and 5, and it's subsection 4 of 426, which is the enabling provision. Your lordships see the words shall assist. And as was submitted by us to Mr Justice Snowden, the way we characterise this, perhaps not entirely accurately, is a gateway provision. for your Lordship's notes, it's supplemental bundle, tab 13, page 187, line 19, as to how we put it.
Sorry, say it again. Supplemental bundle.
Supplemental bundle, tab 13, page 187, line 19 onwards. Our submission is, and I don't think this is controversial, but this is just one method of invoking the court's power to assist. The section creates no rights, it addresses remedies. And I'll come back in a moment to the central issue in this case as to what that actually means. But whilst we're with Section 426, it's just worth bearing in mind that this was the first of Lord Collins' 4 categories or 4 methods, the fourth of which we see from his paragraph 29 was the common law. Now, my lords, the only way to understand the genesis of Section 426 and its purpose and effect is to have regard to the very powerful and careful analysis of this court in Hughes and Hanover, which your lordships find at 41, tab 41 of the third authorities bundle. And my lords, the facts of Hughes and Hanover are certainly for our purposes not relevant, but the distillation of the principles is highly relevant. And for my part, I don't think your lordships need to understand or see the facts or recall them. The holding, which I invite you to read in its entirety, contains pretty much all that I would like to say about that case, although I'm going to show you some of the things that Lord Justice Moritz said in his judgment.
Yes.
Now, my lords, what Lord Justice Moritz did in this case, if we turn to page 507 of the report, was to review all of the reported decisions on 426 and its predecessors in the bankruptcy legislation. And starting at letter D on 507, and I'm not going to read this, we see that he identifies first only 4 reported decisions of courts in England and 1 in Northern Ireland concerning the construction or application of the predecessors. And he goes through those. Your lordships first have Levy's Trust, then Galbraith and Grimshaw on the same page. The third case is at the top of page 508, which is Osborne. Again, a case referred to by the judge in our case. At the foot of page 508, the fourth case was a Northern Irish case v Jackson. And just in passing, if your lordships look at the top of page 509, letter A, the court in the Republic made an order for a request to be made to the court in Northern Ireland for an order declaring the real and personal estate of the bankrupt situated in Northern Ireland vested in the trustee of bankruptcy. To cut a long story short, between E and F, one can see that the vesting order was in fact made. Then the fifth case is at letter H, which is Mr Justice Goulding's decision in Rea Debtor ex parte the Viscount of the Royal Court of Jersey. And then, if I could jump to page 511, just so that you can see the structure of this, at letter C, Lord Justice Morritt then embarked upon a review of the cases, as at that stage, on section 426. And he identified 3 reported decisions. The first of Mr Justice Knox in Re Dalhold. 2 pages later at page 513 of the report. The second case was Mr Justice Ratty's decision in BCCI number 9. And lastly, he came to Sir Richard Scott's decision in Focus Insurance on page 514 between B and C. I've done that very quickly, and it's just so that one can see the conclusion is based on that review, and it appears at 515 letter D. And it's a conclusion that we rely on in our grounds of appeal and in our skeleton argument. In my view, this historical survey of the authorities whose statutory predecessors to 426 reveals a number of material propositions. First, in all the earlier cases, the assistance afforded to the requesting court was the result of the exercise of this court's general equitable jurisdiction. Thus, receivers were appointed in Re Osborne, Re Jackson, and Re Debtor so as to give control over the assets here of the person made bankrupt in the other jurisdiction. There was no suggestion in either of the earlier statutory provisions, nor in the cases that the courts here were somehow limited in their jurisdiction to afford assistance to what they were entitled to do under the express provisions of the Bankruptcy Act then in force. And then he goes into various other safeguards that the 426 cases have put in. And if I could then jump down to letter H, so in all the cases in which assistance was actually being sought, that is all of those to which I have been referred, except Re Levy and Galbraith, the judge concerned has recognised that the requesting court was not entitled to assistance as of right. There's some discretion in the courts here to determine whether and if so in what terms assistance should be given. And then over the page at 516, after letter E in the paragraph that starts, the earlier statutory provisions referred to the request of the other court as being sufficient to enable the court to exercise its discretion. And then he says, but the jurisdiction which might be exercised was not so limited. Thus, a request to the High Court in England for assistance in a form it could not give did not inhibit it from exercising its general equitable jurisdiction to appoint a receiver. The fact that the jurisdiction to do so did not arise under the Bankruptcy Act for the time being in force was immaterial. And then finally, at the foot of the page, he talks about the purpose of subsection 5, which is the subsection which identifies what law is available. It's not to reduce that jurisdiction or those powers, but for the purpose of section 4, only to extend them. Thus, the court in England, faced with a request from a relevant country, may, in respect of the matters specified in the request, apply either the insolvency law of the relevant country concerned or its own insolvency law. But itself, this would not be of much help for the courts of the relevant country, would not normally see much point in making a request to the courts of England in preference to applying its own insolvency law. It would not do so. It would be unlikely the court in England could. And then he goes down and ultimately he says it's between B and C, the sentence which begins, thus there is available to the court in England when asked for assistance by a court of a relevant country under section 426, A, its own general jurisdiction and powers, and either B, the insolvency law of England and Wales, as provided for in the Insolvency Act 1986, or so much of the law of the relevant country as corresponds that comprised in B. In the case of B and C, but not A, the court in England is entitled to apply such law on the hypothesis as to jurisdiction and so forth. And finally, at the foot of this page, 517H, he refers to the obligation to assist. It would, in my view, require very clear words to justify a conclusion that the Court of England was not intended by Parliament to perform its normal function of seeking to do justice in accordance with the law. There is no such indication. According to the function of the Court under Section 426 must be to consider whether, in accordance with the three sources of law that I earlier identified as A, B, and C, the assistance may properly be granted. If it may, then it should be, thereby discharging the statutory duty. And then, but if it may not be properly granted, then it should be withheld, or it must be implicit in the fact that duty is cast on the court. Duty is qualified by reference to what the court may properly do as a court. Of course, if the court in England cannot do exactly what is sought, then it should consider whether it can properly assist in some other way in accordance with any of the available systems of law. And those systems of law are his A, B, and C, the general equitable jurisdiction of the court, general jurisdiction of the court, plus the Insolvency Act, plus the Foreign Insolvency Act, insofar as it's not inconsistent with our Insolvency Act. And my lords, I'm wearying you with Hughes and Hanover, because although it was cited at some length to the judge and similar submissions were made, it doesn't appear in his judgment, and he doesn't address the submissions. And if one turns back now to his judgment, again, just before I get to the look at the reasoning in his judgment, it's quite instructive that when he, at paragraph 219, came to the end of his review of the authorities, and at that stage he was reviewing Osborne, which had been decided in 1932, Mr Justice Falk's case. He then started his paragraph 220 with the sentence, "There was little, if any, further analysis or development of these principles over succeeding years." And then he refers to Cambridge Gas, which of course was 2006. And what he missed out there was the analysis of this court, of the entire jurisdiction, materially for these purposes, in Hughes and Hanover. So having jumped from Osborne to Cambridge Gas, as we'll see in due course, he then was able to make some points which we say were not available to him.
I mean, to be fair, of course, Hughes and Hanover is really a Section 426 case. You say you can derive from it points that help you, but in terms of what the judge is saying, he says you get the common law principles seen at an earlier stage, and then you jump through to Cambridge Gas. Well, Hughes and Hanover is not a common law case.
Except for this. But of course, the cases he's reviewed up to this point, it's my fault because I haven't taken you through them,
Include Section 426.
Are largely 426 cases. And his ultimate reasoning is that, well, if it's a 426 case, it doesn't help you.
Yes.
And because he didn't take into account, we would say, what Justice Morris has said in Hughes and Hanover, where he's saying, well, the 426 cases are cases where, having come through the gateway, you then ask, well, what assistance may I give? And ironically, most of the cases end up, because they're about property, providing assistance based on the general jurisdiction of the court, which is the very jurisdiction that we're invoking, not on the rather bespoke provisions of Section 4265, which applies by way of a hypothesis, the insolvency legislation, local and foreign. And so our submission in due course is that none of these assistance cases in any way offend the Immovables Rule. Because the Immovables Rule is something that we all accept, which is that the foreign bankruptcy order does not operate ipso facto to vest any immovable in this jurisdiction in my client. All of these authorities are about quite frankly, mitigating against that rule, sidestepping whatever metaphor one wants to use. That's why assistance is required. And so the short point, based on Hughes and Hanover, before we get to the reasoning and the judgment, is that identifying a case as, quote, a 426 case, and by that I include the predecessors to 426, does not assist in identifying whether powers are available at common law. Because most of the Section 426 cases, as Lord Justice Morritt has demonstrated, were in fact resulted in the exercise of common law powers.
I'm very sorry. I'm clearly missing something. In the light of that submission, why do we spend time on Hughes and Hanover?
Because the reasoning in Hughes and Hanover is, I would respectfully suggest, the reasoning that Mr Justice Snowden has overlooked. What he has done is said, well, the cases you've cited to me are 426 cases. They don't help you. What Lord Justice Morritt is saying in this court is that, no, when you analyse the powers that were exercised in, not all, but many of those cases, they were indeed the common law powers. It just so happens that the gateway was Section 426, as opposed to the common law.
I mean, the judge's premise is evidently that you require the statutory gateway before you get at the common law powers.
Of course.
And you obviously quarrel with that.
Well, my Lord...
But that's why he hasn't seen Hughes and Hanover as important, because he thinks you need the statutory gateway.
Well, he may have thought that. But, of course, the gateway for us at the common law is the ability to rely on modified universalism and apply for assistance. That's our gateway. It's the fourth method listed by Lord Collins. And staying with Lord Collins, whether you use his first method or his fourth method, the common law powers are available. I readily accept that if you use the first method, and that is to say, a relevant country's court is making a request, that may well be more powerful in terms of the desire to assist. I accept that. But we know from the trilogy of cases now at the highest level that in the fourth method, the common law method, the court will assist and will do all it properly can at common law, save to the extent that either local laws or public policy should dictate otherwise. And so it is, I would suggest, if you think of it in terms of Lord Collins' four methods, they are gateways. The underlying rights, certainly 1 and 4 are. The underlying rights are the rights that I have in Russia. And the question is, should they be recognized here? And if they are recognized here, should I have a remedy in respect of them? And the remedy of, as an example, a vesting order, a receiver, or a personal injunction are all common law for these purposes, not 426. And all I mean by that is that they're not the Insolvency Act remedies, they're not the remedies of the foreign court.
Yes, you're using common law to cover equity in this particular instance.
Yes. And so we do say that the omission of Hughes and Hanover and the reasoning in there of Lord Justice Morritt in his extensive review of the authorities on the question of power is a material omission in this judgment and might explain the ultimate disposition. Could I now turn to that reasoning? And I think the best place to start, if I may, is back at paragraph 112. Where Mr Justice Snowden explains why he sets out paragraph 111, section 426, it's the last sentence. I've set it out in detail because it is statutory predecessor and relevant to some of the key authorities to which I was referred. And then at paragraph 199, jumping on considerably, I think is the next relevant paragraphs for these purposes. He records Mr Bedzhamov's submissions, well, only friend's submissions, that cases where assistance given in respect of immovables were either, you see there, based on statutory power, or cannot survive Cambridge Gas. So that they were the submissions that were made to him. And we would say, just so that your Lordship has that point, I appreciate you'll know this. One, the first submission is wrong because section 426 is not relevant when assessing the extent of the powers of common law. And secondly, Cambridge Gas, in its material aspects, is not only alive and kicking, but vibrant. What Mr Justice Snowden then did was to look at the textbooks. First of all, he looked at Fletcher, and for present purposes, it's the last sentence, paragraph 201. Indeed, the English court may empower the trustee to effect a sale of such property by formally appointing him a receiver of the bankrupt's property here, clothed with the power to sell the same and to deal with the proceeds in accordance with the provisions of the Lex Concursus. And he cites, as Mr Justice Snowden notices, he cites for that Levy, Cooperman and Osborne. And then he cites from Sheldon, from his chapter on the common law assistance, so that chapter 10, and you'll see that he says effectively the trustee is receiver with authority to sell, so he makes the same point in his book. And in paragraph 204, authority for that was said to be Cooperman and Osborne. And we dealt with paragraphs 205 and 206. And then between, he then reviews the authorities, and as I mentioned, at 219, having reviewed Levy, Cooperman and Osborne, at 219, he finishes with the order made in Osborne, and then goes to Cambridge Gas, and proceeds then to deal with the trilogy of cases, the highest level, namely, in fact there are 4 of them, including HIH. He deals in the ensuing paragraphs, all the way up to paragraph 244, with 240, I'm so sorry, with Cambridge Gas, Rubin, Singularis and HIH. And then he comes to his analysis at 241. And what he says at 241 is that, yes, modified universalism is part of English law, and that's not in issue. He then says at 242 down to 245 that none of the English cases involved the making of a vesting order, and that is, with respect to him, correct. And then he deals with Cooperman at 246. He says it's the only case in which any order for assistance in relation to a move of property has been made in the absence of a statutory power, and the order was for the appointment of a receiver of the rents and profits with power to sell the same, remit the proceeds to the foreign trustee. And then he described it as an unsatisfactory decision, no contrary argument. The judgment only insists of one sentence setting out the order to be made, but giving no indication of the basis upon which the power to do so was thought to exist. And then from 247, to the end of 250, he sets out his views on the extent to which the court has power to appoint a receiver. And at the end of that, he comes to his essential reasoning in 251 and 252. It's right to point out, just staying with the structure, that after that, at page 253, paragraph 253, he embarks upon the as-if theory. You'll see in the first sentence, having regard to the warnings given by Lord Collins and singular, I would also decline any invitation to extend the common law in the instant case. I mean, for what it's worth, I mean, such an invitation wasn't made, but here, and your lordships have a second ground of appeal on this, he treats our application for assistance as if we were trying to graft ourselves onto the CBIR, and as if we were doing the very thing that Lord Collins and the board said that you can't do in singularis. That,
you say, well, that's not what you're trying to do.
No, not at all. No. And that was not something that was put to us. It's not a thought that we were aware of. It just emerged in the judgment. It was not how the case was put by the other side.
If you were asked the same question as recorded in 247, would you now back your answer by reference to authority?
My lord, certainly. There's a line of cases, starting with International Tin Council, then Masri, then Tassarif, and now Convoy in the Privy Council, which make it plain that the suggestion that the court has very clipped wings when coming to consider whether to appoint a receiver is wrong in principle, and that the court can appoint a receiver in many and varied circumstances, that the overriding consideration is one of justice. I'll come to those authorities shortly. And in fact, because I've got to do it at some stage, my lords, could I do that now? The starting point, I think, is to look at the decision in Masri, which I'm just looking for the reference. It's, I think, it's in 3. Yes, it's in tab 58. So, in Lord Justice Collins in Masri, paragraph 183, page 498, refers to the decision of Mr Justice Millett in the International Tin Council decision. In the last sentence of paragraph 183, he says, the court confirms, page 302, that demands of justice must always be the overriding consideration in considering the scope of the jurisdiction under section 37(1), in particular to make orders to render any other order of the court effective. And of course, section 37(1) is the statutory power to appoint receivers.
Well, to be clear, I assume what you submit is that the analysis is exactly the same as in 4M the Root. That is to say, the power originates from the equitable power exercised by the Court of Chancery and the principles developed by that court. It's therefore a general equitable power to be exercised in accordance with the equitable principles. It is recognised by section 37 of the Senior Courts Act 1981, Section 37 is not the source of the power.
I agree. That is a much more accurate way of putting it. I agree. If one now goes with that in mind to tab 61, which is the decision of in Tazarov, the Privy Council, paragraph 56. Your Lordships will see.
I beg your pardon, could you give me the reference?
Yes, it's tab 61, page 1734. And it's, again, Lord Collins, or this time Lord Collins, where he refers again to Masri. Jurisdiction could be exercised to apply old principles to new situations. Masri number 2 confirms or establishes the following principles. 1. The demands of justice are the overriding consideration in considering the scope of the jurisdiction under section 37(1). And 2. The court has power to grant injunctions and appoint receivers in circumstances where no injunction would have been granted or receiver appointed before 1873. 3. A receiver by way of equitable execution may be appointed over an asset whether or not the asset is presently amenable to execution at law. And 4. The jurisdiction to appoint receivers by way of equitable execution can be developed incrementally to apply old principles to new situations. And if your Lordships finally then turn to the 4th volume of authorities, tab 72, paragraph 147.
Sorry, which?
72, Lord.
Yes, thank you.
Which is on page 51 of the report, looking at the bottom of the page. This is Lord Voss's, Sir Geoffrey Voss's judgment in the recent decision of the Privy Council in Convoy.
And I'm afraid I didn't get the paragraph number.
It's paragraph 147.
147.
And I show it to you no more than this, that the Chancellor here is plainly approving, as you'd expect, of the very same formula and words.
He was dissenting, but not in this respect.
Exactly. And that's consistent with the entirety of the judgments, in particular judgment of Lord Legate in Convoy, which gets away from the idea that one is straitjacketed by the need for causes of action and so forth. And so, my lords, we don't accept that the narrow way in which Mr Justice Snowden appears to have approached the question of his power to appoint a receiver was correct. It's not consistent with those authorities. And there is another point here, and it's this. In this case, of course, there are two stages. We applied for recognition. Recognition was granted, and in the ordinary case, the court would go on to consider what remedies to grant. Had it done so in this case, there is no doubt that we were on the beginning of a journey, not the end of the journey, because, first of all, there is the dispute as to the security. Clement Glory alleges that it has valid security. Mishkondaria allege they have valid security. And on any view, there was going to be a long-ish period following the appointment of the receiver when, absent agreement between the parties, there was going to have to be a series of decisions as to the validity of security and the proper destination of proceeds on any sale. And that, of course, is another obvious occasion to appoint a receiver to hold the ring.
does that really take you any further? I mean, I quite follow. If you've, well, put it differently, if you could claim the property and there were a rival claimant to the property, it might well make sense to have a receiver to hold the ring. But the premise of that is that you can claim the property. And I don't think you quite say that. So the live question is whether you can get hold of the property by the appointment of a receiver, which is a slightly different question.
Well, I may not be answering this directly, but can I do it this way? I think it probably is quite instructive to ask what it is that's been recognised. So my status has been recognised, to use the judge's own words. And of course, my status is as the bankruptcy trustee and financial manager of Mr Bedzhamov. And that means that, of course, I have, the court recognises, the powers of management over his property. It's not as if Mr Bedzhamov is a creditor or a third party. As between the two of us, I have, the court has recognised that I am the one with the power of management and the power to administer the property. And
that's plainly right in relation to movables, but it sort of begs the question in relation to immovables.
Well, what I wonder, does it? Because, and in a sense, this is at the heart of this. So far as immovables are concerned, the only problem with immovables is that I don't have title. That is the Immovables Rule. When the court recognises the bankruptcy order in Russia, it does not recognise an automatic vesting. But it does recognise everything else. It simply says that the property remains registered in the name of Mr Bedzhamov of HM Land Registry.
When you say it remains registered, you mean he doesn't get, the trustee does not get title to it. I mean, it's not just a registration point. Title does not pass.
Legal title does not pass.
Equitable title doesn't pass either. No title passes.
Well, it's a moot point as to, following recognition, what my interest is. Plainly, I have an interest on any view of life, because I am his trustee, and I can direct him as the legal owner to do what I think is right in accordance with the performance of my functions.
Sorry, when you use the word interest in that sentence, you're saying you are, you take an interest in what was going on. You're not saying you have a legal or equitable interest.
Well, on one view, I am, in this sense, not a legal interest, I could not, but an equitable interest. I am saying that he holds the property on trust for me, for all practical purposes.
For all practical purposes. Do you mean he does hold the property on trust for you, or he doesn't hold the property on trust for you?
He does, in the sense that the effect of recognition is that it is accepted that, as between us, under Russian law, he holds the property under my direction.
And that seems to be the question again, to an extent. I mean, you're recognised as the trustee, but we also recognise the Immovables Rule.
Yes.
And in those circumstances, it isn't the least bit obvious that recognition of you as a trustee, well, first of all, it doesn't seem to follow at all that you get any kind of title, legal or equitable, to the property. And not having any title, legal or equitable to the property, it isn't at all obvious that you have any control over it, albeit that it may well be right to give you the benefit of rent and profits from it.
The difficulty with that, with respect, is that it doesn't reflect the fact that, as between me and the bankrupt, my title is now recognised in terms of being able to have complete dominion, as it were, over him in relation to bankruptcy assets. That's the bit that's missing out of that formula.
And that seems to be the question. You have complete dominion in relation to movables, but whether or not you have complete dominion in relation to immovables is a different point.
Oh, my lord, I understand the point there. It is right that I am operating on the basis that in personam, as between me and the bankrupt, he must do what I tell him to do in relation to the bankruptcy assets. And that is the effect of recognition. I mean, were it otherwise, the Immovables Rule would be elevated into some sort of complete insulation of real estate in these cases.
And that would be a complete end to modify universalism.
It would be, it had not occurred to me that it might be argued by my friends that I have no ability at all to, as an example, tell him not to sell the property. He may not listen to me, and it may be a matter of my getting a remedy, but having been recognised in this court as his trustee, what comes with that is a recognition that it is me, as it were, who calls the shots for these purposes and not him.
I know this doesn't fully reflect modified universalism, but of course there is ultimately a remedy if you don't have a remedy in any other way, in the sense that you can get a bankruptcy order here.
Well, my lord,
the trustee would then.
I can't ask for it. There's no such thing as an ancillary bankruptcy.
No, well, you can't, but a creditor could.
That's my problem. At the moment, there isn't a creditor who can. The Russian creditors can't because they've submitted to the Russian bankruptcy in respect of their debts. There would have to be a new creditor here at some future time, during which, of course, he can sell and alienate the property.
I haven't thought that through, but I query that. I would have thought that there was a mechanism by which a further bankruptcy order could be made here.
My lord, certainly not at my instance. There's no.
Do you mean at the trustee's instance?
The trustee has no ability to.
No, that may be, but it isn't obvious to me at the moment that a creditor couldn't get a bankruptcy order here.
Well, there isn't such a creditor. That's the difficulty, because the Russian creditors. There's authority in the bundles to the effect that the Russian creditors may not, if they have registered and participated as creditors in the Russian bankruptcy in respect of those debts. What you need is a creditor with a debt outside of the Russian process who wants to bankrupt, or attempt to bankrupt Mr Bedzhamov in the UK. And that's entirely out of my hands.
Yes, I mean, I haven't thought it through, but I query whether the proposition that no one could get a bankruptcy order here is right.
Well, Lord, just for the for the note, the authority to the effect that the Russian creditors cannot petition is the decision that you'll find. I think it's tab 68. Yes, tab 68. PJSC, VTB Bank and Lyubov, and it's the fourth holding in that case. As a matter of Russian law, a creditor to be registered and recognised in the Russian bankruptcy proceedings would not have the right to take steps separate from its participation in the proceedings, such as petitioning for bankruptcy in a foreign jurisdiction.
Yes. Well, I mean, it may not matter, but I query whether there is no mechanism by which, in circumstances where the Russian trustee in bankruptcy wants it anyway, it's impossible for a Russian creditor to come here to reach assets that could not, on this theory, be reached by the Russian bankruptcy.
Yes, well, the state of the law at the moment is, I think I'm right in saying, to the effect that the Russian bankruptcy, if you participate in it, that prevents you from having standing here to petition. But there may be another creditor or a creditor with a different debt, which perhaps can petition, but it doesn't really help the trustee, because that could take, even if such a debt exists, months, years, and so forth. In the meantime, if my only friends are right, all of the real estate of this or any other bankrupt can be realised as if he were not bankrupt.
I mean, I quite follow. We ought to take the break, but I quite follow that if you need to find some other creditor, there's a problem. But if it were possible in some way for an existing known creditor or the trustee to do something, well, there's been plenty of time to do something.
Well, my lord, if you take the bank, having participated in Russia in respect of its debt over there, if insofar as it has a separate debt here, it's trying to vindicate that in the proceedings, which have not taken place.
Yes, there's a curious feature that it's trying to pursue a personal claim in circumstances where it's got a bankruptcy order in Russia. That's by the by.
It is by the by for these purposes. I mean,
Yes.
the point I'm making is that one would have to, a trustee would have to just hope that someone would come up in their private interests and selfishly try to bankrupt the bankrupt here, which cannot be right.
We'll break for 5 minutes.
Right.
All right.
Live on YouTube.
It's pressing.
It's gripping stuff.
Once
15
enough.
people are watching this.
How many?
15.
So,
Global audience.
my children, who else?
Oral only. They're with pictures. With pictures.
Yes, 15 people.
I thought they've seen our training. In fact, a moment ago I saw us. It's still live now. We're in here.
Yeah.
Oh.
Oh no, there's only 13 watching now. Your viewing figures are going down.
It's pressing it for the 90.
I forbid you to do comparison.
All right.
Mr. Davis.
My lords, before looking at some of the cases, could I just ask you to reflect on this? The judge, consistent with Dicey 217 and the narrative in Dicey explaining 217, and with Lord Sumption, has found that the court in this case had the power to appoint a receiver of rents and profits. It is instructive to reflect on why that would be. If the property is something in which I have absolutely no interest of any shape or form due to the Immovables Rule, on what possible grounds could I have the rents and profits from it?
Well, they're movable.
Well,
They may be the fruit of a movable property, but once you've got them, they're not a movable property.
well, if the rents are movable, then why aren't the proceeds?
Well, they would be if the property were sold, perhaps.
In which case, one can see that one is simply talking here about timing.
Yes, I see.
And we are allowing the Immovables Rule to do too much.
Yes, I see.
And your point on timing is that Mr. Bedzhamov himself wants to sell the property.
He does. He's desperate to. And he wants to. It's human nature. He wants to gobble up proceeds and make sure that we don't have them as his trustee. The rights and wrongs of that are irrelevant for these cases.
Well, he's got other calls upon the money.
He does.
He would say.
Yeah. But my lord, I think it is worth reflecting. You know, Mr Justice Snowden has said, yes, I could appoint a receiver. I could let you have the rents. I could let you have the profits. But I can't give him a power of sale. And one has to ask juridically, what is it that restricts him in that respect? Because for all intents and purposes, save for title, and that's what Rule 217 is all about, that is a bankruptcy asset.
I'd certainly be interested to hear what Mr. Fenwick and Mr. Robbins say about what the status of the proceeds of any sale would be.
Yes, well, their case is that they're immovables. They've made that absolutely plain.
Yeah.
Sorry, they say
The
proceeds of sale
Yes.
are removable.
They do. They say it emphatically.
And I
say
can
that
see why
this
they might
property
need to
is-
say that.
They say, well, quite, but this property is insulated for all time, as would any property in a jurisdiction where facts such as this might arise. And since Brexit, of course, this could all have happened if you assume that we were never in Europe, in Germany or France. It's quite wide-ranging. Because if
But your
so long as-
position is that the proceeds of sale are most definitely movable.
Oh, my lord, yes.
Flit around the world at the touch of a button.
Absolutely, my lord. I mean, we're all we're shouting in an empty room otherwise. And so we respect at all times the Immovables Rule. We have never once suggested that it has automatically vested in us, pre or post recognition. And nothing that we are asking the court to do, including an in personam injunction against the bankrupt, violates that rule. Nothing. It simply seeks to recognise it. It is a problem. We have to do more because it's immovable. And that is why you have to come to court, somewhat cap in hand, prove that either there's been submission or domicile or whatever, and then crave assistance. My lords, I do think it's important that I take you, albeit relatively quickly, to the core decisions which Mr Justice Snowden analysed. And can I do it in tandem with the judgment? So keeping open the judgment, and the cases that I'm referring to, if I just remind you, at paragraph 206 of the judgment, he cited the note which he approved from Dicey, and then Cooperman, Levy and Osborne. And then in chronological order, from 209 onwards, he referred to those cases. And in some respects, I don't need to go further than looking at the passage and summary that the judge himself provided for us. So in relation to Re Levy, which is an odd case, I'll explain what I mean by that in a moment, paragraph 209, that was a decision back in 1885. And as you will see from his summary of it, it's based on a hypothesis. So if I could invite you just to read paragraphs 209, 210, 211, and the quotation from the judgment of Mr Justice K. Your Lordships will see from the quotation from the judgment of Mr Justice K that the hypothesis was that he said, I am bound to infer that if the, let's call him a trustee in New South Wales, had applied under, let's call it 426, then. And so it's all over to in any event. And then towards the end of that, he says, therefore, on his becoming bankrupt in New South Wales, the real estate in this country became liable at once, or rather would have become so liable if he had belonged to him indefeasibly for his life, to be attached and taken possession of by the proper authority in New South Wales. And you see those words, and taken possession of by the proper authority. If I could ask you just to note that at paragraph 244 of this judgment, Mr Justice Snowden's judgment, he did not like those words and said that they were obiter. we would say, for what it's worth, that a trustee in the position of my client can be permitted to take possession of the property, in this case in Mayfair, so long as, of course, it's not suggested that one is doing that as a result of the automatic vesting pursuant to the Russian statute. The next case that Mr Justice Snowden analysed was Osborne, starting from page 215. That was a decision in 1932, and it's behind tab 27. This is more relevant because this is, at least, a trustee in bankruptcy applying in respect of an Isle of Man bankruptcy for assistance to the English court. It's not a case where the bankrupt appeared, although the bankrupt had been served. There's an application for assistance via the court in the Isle of Man under section 122, and you'll see in the head notes on the first page in the reports, page 189, that Cooperman was followed. And Cooperman, of course, was not a 426 case or 122 case. That was a common law case. And we can see that within the judgment of Mr Justice Farwell, on page 194 of the report, he, having noted that the bankrupt didn't appear, at the first hole punch, I think it's clear I'm bound in the proper case into 122 to assist. And then he goes into that. And then, this is quite interesting, 194, last paragraph, the question of making either a vesting order or a declaration that property in this country has vested in the trustee in the Isle of Man seems to me to be one of considerable difficulty. In my judgment, it's not possible for me to make a declaration that all the rights and interests of the aforementioned bankrupt in the following property, which include freehold property, has vested. I'd ask you just to note that in the trustee, because I do not think it has. That's the immovable rule. In my judgment, the effect of the order made in the Isle of Man does not ipso facto vest the assets in this country in the trustee. But if the trustee desires to get those assets vested in him or to get control over them, his only course is the course which has been adopted in this case of coming to this court and obtaining the aid of this court to enable him to get the control and possession of the assets. Of course, we would say that this predates the modern articulation of modified universalism and the ability at common law to come to court as a gateway as well. Then he says, with regard to the making of a vesting order, which seems to have come, of course, adopted in Ireland, the difficulty that I feel is to that. As far as I know, I have no jurisdiction to make an order of that sort at all under the Bankruptcy Act. That's quite an important point. Of course, I have jurisdiction in a proper case under the Trustee Act to make a vesting order. What jurisdiction in bankruptcy have I to vest in property, in a trustee in bankruptcy in another country? So just pausing there, of course, this is at a time when Mr Justice Farwell, very, very early days, didn't have the benefit of the powerful analysis in the Court of Appeal, Lord Justice Morritt, showing that the three different systems available when applying for what is now Section 426 relief assistance, the first of which is the general equitable jurisdiction of the court. But he correctly recognises that he is able to make a vesting order. But could I just make this observation? Such a vesting order, of course, would only be as of the date of the vesting order, which doesn't offend the Immovables Rule, because you're not at that stage suggesting that the automatic vesting in Russia on our facts or in the Isle of Man on their facts has resulted in the vesting of the property. It is not a retroactive validation, which is why he used the past tense in on page 194. A vesting order under the jurisdiction of the Trustee Act would be from the date of the vesting. And that is a different animal, a different beast, which does not offend the Immovable Rule. It recognises that there is effectively a trustee which is the foreign trustee, and that because it's not vested in him, it should be. And in the next paragraph, he says, that being so, is there any alternative? I think there is, and I think I may properly adopt the course which Mr Justice Asprey adopted. Now, he doesn't mention it, but that's in Cooperman, in a case to which I have been referred. In that case, there was a more difficult case in the sense that the case I had to deal with, the bank was in Antwerp. There were assets in this country which were chiefly leasehold property. Asprey was asked, Mr Justice Asprey was asked, in effect, to vest the property in the trustee in bankruptcy, and the course that he adopted, feeling no doubt the difficulty which I feel is to making a vesting order, was to appoint the trustee or the person who corresponded to the trustee in bankruptcy a receiver without security over the property in question, with authority to sell and retain the proceeds as trustee. That I have jurisdiction to appoint a receiver in bankruptcy, there can be no doubt. And fortified by the course which has been adopted by my predecessor, I think I'm justified in adopting the same course. And then he goes on to look to see what conditions he should attach to the order. So what we get from this is that Mr Justice Farwell is following Mr Justice Asprey, who was exercising a purely common law power in a common law case. And following Reed Cooperman, he appointed a receiver not just over the rents and profits, but also with the power of sale, and gave detailed directions in that respect, as you'd expect. And we know, and this is our submission, our case, that in doing so, he was emphatically exercising common law powers, the very powers which we say Mr Justice Snowden said he didn't have. May I now, still on Osborne, take your lordships very briefly to paragraph 217 of the judgment of Mr Justice Snowden, because there is something that with respect to him we disagree with here. He says this: in giving assistance to the Isle of Man trustee, Mr Justice Farwell was prepared to follow the course of appointing a receiver over the immovable property in England. In deciding to do so, he clearly had in mind the procedure adopted in Reed Cooperman. However, it is equally clear that Mr Justice Farwell considered that he was, and it's the word only able to give such assistance because of the terms of section 122. And then he sets out a passage from his judgment. Now, my lords, I don't know how Mr Justice Snowden justifies the use of the word only there. And it may be that we've missed it. We cannot find the justification for that qualification. And the reality is that it is plain that he followed Reed Cooperman, and that Reed Cooperman was a common law case. And in that case, Mr Justice Asprey, admittedly without giving reasons in the judgment itself, did appoint a receiver with a power of sale. And so when at paragraph 218, Mr Justice Snowden says, Mr Farwell did not have to consider what, if any, jurisdiction might have to give such relief in the absence of section 122, he was following Reed Cooperman, which of course is not a 122 case anyway. And your lordships have my submissions to the effect that when at the end of 219, Mr Justice Snowden jumped to 2007 in Cambridge Gas, missing out, I would suggest, the crucial analysis in Hughes and Hanover. And so, my lords, it's not often one can make this submission, but all the leading textbooks by the specialist writers are not wrong. They are absolutely correct.
Could you just give me the reference for Cooperman's in the bundle?
Yes, Lord, forgive me. It is at 26, tab 26.
Thank you.
I'm never going to suggest that this is a case which discloses any relevant or material learning on this issue. It's the starting point. It's a common law case. Until Mr Justice Snowden, it has always been cited with approval in very many cases and in very many articles. We have been unable to find any case or any article where it has been doubted.
So have I misunderstood? In Osborne, on page 195, he refers to the Bankruptcy Act and the Trustee Act, but to my eyes says, I'm not going down either of those routes.
Yes, he does, right.
But what he doesn't say that expressly. He just says, so what's the alternative? And follows Asprey.
Absolutely.
Without analysis.
Because, well, he plainly has analysed.
But he says that Mr Justice Asprey clearly felt the same difficulty that he did.
In relation to vesting. Yes, so I accept entirely that the Immovables Rule dictates that there cannot be an order vesting the property in the foreign trustee, an order in this court, in the local court, vesting the property in a foreign trustee by dint of, or ipso facto as a result of, the Russian vesting under the statutes. That I accept, because that is the Immovables Rule. There is juridically a separate question as to whether the trustee can be appointed from the date of the order as the trustee and have the land vested in him under the Trustee Act. That's a difference. Because what it is doing there is reflecting the reality of the trustee-bankrupt relationship and not anything validating a purported vesting under the foreign statute on the making of the bankruptcy order in Russia.
I'm not sure I was listening carefully enough. So plainly you say it's possible to appoint a receiver and to give the receiver power of sale.
Yes.
You say it's also possible to make a vesting order direct in favour of the trustee.
Yes.
To take effect from the date of the order.
Yes. And that is what has been done in other jurisdictions. And of course, at this stage, I'm simply inviting your lordships to identify a power which could be exercised, not that it should be, could be exercised at what we've called stage 2. And that the judge was wrong to proceed on the basis that he had no such power. And just to pick up the reference to vesting orders, if your lordships turn up our skeleton argument, and it's paragraph 33. Which reflects ground 1 of our grounds of appeal, in particular 1D, where we allege that the judge was wrong in law and that he was wrong to conclude that the court has no power to make a vesting order in favour of a foreign trustee, and ought to have followed statements to the contrary in leading textbooks and authorities. And in paragraph 33, we refer first to Professor Fletcher, who is the, I think, acknowledged leading academic expert in this sphere in the UK. Then we refer to Lord Hoffman in Cambridge Gas and Lord Collins in Rubin. And your Lordships may see our footnote 15, Carr and Hunter on receivers and administrators, and you have this behind tab 82, refer to the fact that a vesting order could be obtained under the Trustee Act without the necessity of proceeding under Section 30, which I think should read Section 37. And they plainly see it as a route.
So just to understand that, if the basis is Section 44 of the Trustee Act, I'm afraid I don't remember what that says. Have we got that in the bundle?
We have, my lord. It's in, I think it's tab 92. And it's page 754. And we would suggest that the statutory gateway on this occasion is Section 44(2)(7), where the land or any interest therein is vested in a trustee, whether by way of mortgage or otherwise, and it appears to the court to be expedient. And we say we have an interest.
That must mean a proprietary interest.
Yes.
And you don't.
Well, if we have complete control, then we are, for those purposes, regarded as the owner, in the sense of being we are a trustee. I'm so sorry. I'm sorry. No, it is the... I'm so sorry, this is my mistake, I did that too quickly. It is the bankrupt who is the trustee. He's the trustee for us. He holds it on trust for us.
And that takes us back to where we were.
It does. But it's no different from the liquidator who is appointed over the company and the AOST statutory trusts apply. And in that sense, the property is held on trust by the legal owner for the purposes.
So the proposition is that the Immovables Rule doesn't prevent the foreign bankruptcy having the effect of causing the bankrupt to hold the property on trust for the trustee.
But that doesn't affect title. The title, which is all about the local systems of registration and so forth, is unaffected. But he holds it for us. One gets some support from this, from the case of Fogarty, which you'll find in the first volume, at tab 17. It's an Australian case. This was just behind tab 17. It's an old case, 1898 or 1888. No, sorry, 1898. It's a New South Wales bankruptcy with land in Queensland, and the New South Wales court ordered the bankrupt to execute a transfer to the trustee and made a request to the court in Queensland for a vesting order. And they asked for an order that the bankrupt hold as trustee for the trustee. And indeed, as you'll see in the very short judgment of the second half of the page, the prayer of the petition asked for a declaration that the bankrupt held the lands as trustee for the petitioner, in order vesting and estate in fee simple lands in the petitioner as official assignee under the equivalent of the Trustee Act. And the order was made as prayed.
I mean, supposing you to be right in saying that the foreign bankruptcy has the effect that the bankrupt holds on trust for you, then really we can forget about everything else except for Section 44.
Well, yes, in one sense. the trouble is that on the facts of this case, that is correct. But in other cases, not so much. What the oddity about this case is it is the bankrupt himself, not a third-party creditor, who is opposing the recognition of his own trustee. That's a first, in effect. To state the obvious, in corporate insolvency, that's not possible, because all that happens in corporate insolvency is that on the entering into the insolvency process, there's a change of agency. The board goes, the insolvency practitioner comes in as the new agent. But of course, the Immovables Rule isn't engaged either, because the real property is vested in the company, and it's just a different agent who can transfer it, cause it to be transferred. So it's very, very different. But in broad terms, in this particular case, it is right, and we have always said, that we should be entitled to a vesting order, because as between us, everything he holds is for us, for the benefit of the estate, as between us. That is, in our jurisdiction, the classic indicia of a fiduciary relationship on any view. And that is the effective recognition of our status. And so the way in which that vesting order took place in over 120 years or more ago in New South Wales or in Queensland is not that surprising on that analysis. And it's perhaps of note that in Ireland, as indeed Lord Justice Morritt pointed out in the Hughes and Hanover judgment, vesting orders are made. And I don't know whether your lordships have the chance to look at it. I suspect not. But we refer in our skeleton argument, amongst other things, to Reed Drum, which is a decision in the Republic. It's at tab 59 of the fund. It's of particular relevance because it is pure common law, and the gateway was modified universalism. That part of Cambridge gas remains very much alive and vibrant. So the trustee was speaking loosely, a US trustee. You see that from the first page. He made an application under the common law to the Irish court for a vesting order. Now, I readily accept that I don't go this far. Because in this case, the vesting order, which was asked for and granted, did the thing that I say is more of a problem, namely that the date of the vesting was the date of the commencement of the bankruptcy. But, and in my submission, an application under the Trustee Act, if it were otherwise minded to make the order, the court would vest the land from the date of the order. But in any event, we can see that the judge in this case, and this was in 2010, Mrs Justice Dunn, on the 2 pages from the end of the judgment, the page that's marked, and I won't read it out obviously, refers to Cambridge Gas, that part of Cambridge Gas which is alive and kicking, as it were. And on the penultimate page of the judgment, it's not numbered, unfortunately, after the highlighted passage, she refers to some old, ridiculously old, in fact, Irish cases. And if I could just invite you to read the last paragraph, which is on the last page. Finally on this, your Lordships have already seen reference in the judgment of Lord Justice Morritt in Hughes and Hanover to the decision in Northern Ireland in the case called Bolton, behind tab 24, the authorities bundle. And with very great respect to Justice Morritt, I mean, he accurately summarised that case as you would expect. But it's worth just noting that in this case where a vesting order was made, again it's a common law case, could I invite your Lordships at 328 to look at the foot of the page. It's a hybrid in the sense that it would appear that one way or another Mr Justice Dodd was relying both on a form of statutory gateway and the common law. And the form of order made on page 330 first, in the italics, first recognises the appointment of Mr Souter as sole trustee of the estates and so forth to administer the same, and then orders and declares that all the estates and interests and that they are then listed, and they're quite considerable. And finally, are vested in Mr Souter as sole trustee of Bolton, the insolvent, and so forth.
Sorry, where do we find the vested in bit? How far down is it?
Oh yes, it's about 12, perhaps 15. It's the line.
Oh, I see. Yes, yes, I've got that.
And so, when Lord Hoffman talked about assistance by way of vesting assets in the office holder, again, with very great respect, that's in paragraph 19 of Cambridge Gas, he was correct. That is a power that can be exercised in appropriate cases once recognition is granted. The other case, which is the case Lord Lowry, the Chief Justice of Northern Ireland, is Reed Jackson at tab 32. Again, a vesting order was made there. So for those reasons, we very respectfully suggest that the judge was wrong in principle when he suggested that the only power that he could have exercised would have been to appoint a receiver over the rents and profits. But both because, logically, if he can do that, he can do all the other things. And secondly, because there is no principled reason for stopping there and not also, as an example, giving the very same receiver the power to sell or to take possession. That is actually what happened in Recouperman. Recouperman was followed in Osborne, and every single textbook, even including Halsbury's laws, reflects that principle when describing the nature and extent of assistance which might be afforded to a trustee in the position of my client.
Yep.
And so, in terms of our grounds of appeal, my lords, and I just sort of, it's probably unfashionable to actually look at the grounds of appeal. If I could just go to behind tab 1, page 14, in the core book. I can take the rest of this more quickly. I have covered, if I may put it that way, paragraph 1A to D. We say the judge was wrong first to stop at rents and profits and not to give a receiver, to find that he had power to provide a receiver with authority to take possession or control and or sell the property. Secondly, I've taken you at length to Hughes and Hanover as to the existence of such powers at common law. Thirdly, I've made submissions on why Recouperman has become securely part of our law as a matter of jurisprudence. Fourthly, vesting orders I've just addressed you on. I'd like to address you this time quickly, if I may, on the personal jurisdiction over Mr Bedzhamov. Because this is the unique aspect of this case. As I mentioned, in corporate insolvency, this could not arise. The insolvent cannot oppose, as it were, the liquidator. But the unique situation we have here is that the insolvent estate is, of course, embodied in a human being, and there are two legal persons, not one, Mr Bedzhamov and the trustee in bankruptcy. There is no doubt at all that this court has personal jurisdiction over Mr Bedzhamov. And it is that undoubted personal jurisdiction which enables the court to grant relief in appropriate cases. And that, of course, will depend on what it is that the trustee is seeking. Now here, once one accepts that the trustee has been recognised, such that the powers of control and administration over the property are recognised to be vested in me and not the bankrupt, and once one can see that even the possibility that the bankrupt might, as it were, go rogue, and contrary to my desire, my intention, and my directions, seek to realise this property or to diminish its value, that, without more, is enough for this court to grant an injunction under Section 37, subsection 1. Now, my learned friends say, not a bit of it. They say, you have to show that you have a cause of action here. You have some right or interest which can justify the granting of an injunction. There are many answers to that. The first answer is that I have been recognised as his trustee in bankruptcy and financial manager by this court, and he seeks to deal with the assets potentially in a manner which is inconsistent with the bankruptcy. And I seek the court's assistance to prevent him from doing that. The second answer is, of course, having recognised me and put in place on our case more litigation in terms of the nature and extent of any assistance that should be granted. That in turn is a situation where the court would wish to hold the ring at the very least, whilst the nature and extent of the assistance is worked through before the court. Restraining in the meantime Mr Bedzhamov from dealing with the assets on time-honoured grounds. The third possible reason, of course, is the one that is sensitive and the one that we've already touched on. And that depends on the extent to which this court considers that I have any recognisable interest, properly so called, in Berkeley Square.
Do you mean here a
Belgrave
proprietary
Square. I
interest?
keep on calling it Berkeley Square. It's Belgrave Square, isn't it?
Whatever it is, you mean a proprietary interest? Or do you not mean a proprietary
no, I don't need a proprietary interest. In order to, I don't need a proprietary injunction. On my wish list, at the top of my wish list, is an order that he transfer, complete a TR1 with me as transferee. That's the top of my wish list. And the question is, on what principal basis should the court not accede to such an application? I am not saying that I'm entitled to my TR1 because title vested in me when he was made bankrupt in Russia. That's not my case. That's not available to me. I want him to execute a TR1 because I have been recognised as his trustee in bankruptcy. That's the function of assistance. And it's, I stress on the authorities, highly unusual that you have the bankrupt himself challenging the trustee. It is normally a third party with a genuine local interest, obviously usually accredited but not always, and different considerations apply. Here we have three unusual features. The first unusual feature is that the foreign bankrupt, if I may call him that, is present in the jurisdiction and has submitted the jurisdiction to this court. That's highly unusual in itself. The second unusual feature is that he is attempting to argue that even post-recognition, he doesn't have to recognise me in this jurisdiction, which is a tautology. And the third unusual aspect of the case is that he has been dealing with the property, charging it, as it happens with the permission of the court, during his bankruptcy. And each one of those features is probably unique so far as reported case law is concerned. But our short point is that the court has personal jurisdiction over him, and we have, on any view, sufficient interest to enable us to obtain an order against him, whether it's to restrain him from dealing with the property, or indeed to execute a transfer in our favour or in favour of a purchaser. And the decision recently of the Privy Council in Convoy, in particular the view of the authorities as to the ingredients required to invoke what is now Section 37(1) of the Supreme Court Act, is entirely in accord with respect with the submissions I've just made.
Can I put that into my own words and see if I've understood it? So what you say is that the equitable jurisdiction, let us say, to appoint a receiver or to make a vesting order, it matters not for these purposes, is one that can be exercised wherever the defendant or respondent is subject to the personal jurisdiction of the court. It has to be exercised on a principled basis. And you say the principled basis here is modified universalism.
My Lord, yes, in a nutshell, that's it.
Now, where that leads us to is that I think you accept that the court has a discretion to exercise.
Yes.
It's not in any sense automatic.
No.
And the fallback position that is put forward by the respondents to this appeal is that if contrary to their submission, an order should be made, it should be on terms. And in particular, it should be terms that parallel those under the WFO with regard to living expenses and legal costs. What do you say about that?
Well, I've not addressed you at all on discretion, and we have, in fact, addressed this at some length in our skeleton argument, which is behind tab 13 in the core bundle. Because at the moment, I've been addressing you only on power, as it were.
Yes.
And I was aiming to address you on this in response, as it were, to my friend's appeal tomorrow. I'm happy to indicate to you now that our position is as set out in the in our skeleton argument, and
sorry, can you give me the
relevant
reference
paragraphs.
again? Which paragraph?
It starts at yes. It's addressing Mr Justice Snowden's point. Yes, it's ground. It's ground 7, and it's at paragraph 37, where we address Mr Justice Snowden's observations at the end of his judgment at 271 about the standing to benefit from the continued pursuit of the UK proceedings. And what we say is, first, at 37.1, we don't necessarily stand to gain anything.
Sorry, I must be looking at the wrong thing.
It's behind, it's our respondent skeleton argument behind tab 13 in the core bundle, page 17.
255.
It may well be. I'm on internal page 17.
Yeah. Which starts with paragraph 35 and goes down to paragraph 37.
Indeed, and it's paragraph 37.
And what were you referring to? Because I couldn't find it.
So from 37 onwards,
Yep.
37.1, we are demonstrating, or seeking to demonstrate, that the WFO is probably not for our benefit.
Well, yeah, but that's a slightly different point, isn't it? Because what I'm asking you about here is, and the reason I'm asking the question is that, understandably, the position you adopt in your skeleton argument is to say that if you're right on power, then the matter should be remitted.
Yes.
And I understand that submission, but what I would like to explore is whether that's A, necessary or appropriate, B, if we don't remit it, what we do.
Yes, I see.
Because there's a fallback position being advanced on the other side to say, and it may be that, in fact, the other side would agree with the suggestion that the correct way forward is remittal. Let's assume that this court is to review, is to exercise the discretion itself. Just make that as an assumption
Yes.
at the moment. And the question, therefore, is, well, what's the appropriate exercise of discretion?
Yes, well, there's a cut-off point when looking at the effect of the WFO. And the cut-off point is things that have happened prior to our application for recognition and things that have happened since then. And so it may well be that when looking at, let's grasp the nettle, the Mishkondaria charge of £5 million. A large part of that, and I can't be any more specific, I'm afraid, secures indebtedness and fees that were incurred prior to the recognition application. Another part of it secures fees that have been incurred since the application for recognition. At a hearing, when one is looking at, on this hypothesis, the possibility of granting some injunctive relief, the conditions would need to be formulated, possibly by reference to what happened when. And if there are perhaps three, there may be many more, but three relevant periods or phases. The period up to our application for recognition, the period from then to now, or to this court's judgment, and then the period going on after that. In other words, one gets to the point, if one assumes for a moment that once recognition has taken place, and the court is looking to see whether there should be a sale, which everybody seems to think there should be, and whether then, therefore, there should be a working out of who is entitled to the proceeds after sale. The two variables are clamant glory and Mishkon Derea. And Mishkon Derea splits into two. It's Mishkon Derea's existing 5 million and the fact that they are seeking a variation in order to increase the indulgence of clamant glory and increase, as it were, top up the first charge.
I see where you're going, and I understand the points you're making. But can I pose the question in a slightly more dramatic way? Let's think about his living expenses.
Yeah.
Now, as I understand Mr. Bedzhamov's position, what he's saying in effect is that even though, of course, the normal rule would be that creditors shouldn't be prejudiced.
Yes.
And therefore the fact that Mr. Bedzhamov needs, he says, to feed himself and his family, that wouldn't, in the ordinary course, be a reason for prejudicing the creditors. But what he says is, here, you are coming to this court, seeking the assistance of this court, seeking a discretionary remedy, and, he says, having regard to all the very rather peculiar circumstances in this case, you've identified some of them, but he would say there are more, the appropriate exercise of discretion would be to limit your remedy in such a way that he can continue to pay his own living expenses. What would you say to that?
Well, forgetting the detail and just dealing with the principle of it, the answer to that is we, of course, have not consented to the WFO. It's not necessarily for our benefit.
Oh, indeed not. I appreciate you say it's not. I mean, there's an issue about that, but I understand you say it's not.
Yes, and there isn't a principled reason for visiting the bankruptcy estate in Russia with his living expenses just because he's chosen to use bankruptcy assets to defend proceedings in the UK. That's what he's done. In knowledge of his own bankruptcy.
Well, to be sure, and I don't want to pursue this at any great length because there's limited amount of time. But the argument that's being put forward is it's the price of assistance.
Yes, I understand.
It's the price of being able to step round the Immovables Rule.
And I think you might smile at this, but I do truly believe that if we get to that, it should be the subject of a separate hearing. It's complicated.
You say that the factors affecting the exercise of discretion are not straightforward. It requires proper consideration at first instance and not being done for the first time on appeal. And
it's not just batting it away, my lord. That's truly sincerely held belief that it's potentially complex. It certainly involves looking forensically at some facts.
All right, I understand. Thank you.
My lords, returning then to the grounds of appeal, and with having a thumb in our skeleton argument in support of those grounds. So far as the grounds of appeal are concerned, I have already extremely briefly made the submission I want to make in support of ground 2. In broad terms, we didn't put the case by analogy. We don't now. We, with great respect to the judge, don't think that this was raised by anyone at the hearing. It came as a surprise for the first time in the judgment. We didn't invite him to do anything of the nature that he suggests in paragraph 252 of his judgment. And you have our submissions in paragraphs 37 to 42 of our scoping argument. I wasn't intending to say any more in opening on that.
You've probably dealt with 3 and 4 as well, in a way, haven't you?
I have. And 5, in a strange way, touches just slightly anyway on what my Lord Justice Arnold has just been putting to me, in that what we have been deprived of here was any submissions at all at stage 2, because we all made submissions only on a matter of principle, recognition, and whether he should be recognised and she should be recognised, and the judge concluded that because he had no power to assist, that was an end of the matter, and that's why he made his order. And we should have been given the proper opportunity to address the court at stage 2 on the appropriate relief to be granted. And that would, of course, include, insofar as personal orders are concerned, consideration of any conditions attached to that order.
So if you succeed on that ground, what are you asking as your remedy? Are you asking this court to deal with it after another hearing, or are you asking for it to be remitted?
Well, of course, Mr Justice Snowden is now in this court, but to be remitted to another judge, Lord, yes.
I suppose theoretically it could be remitted to Mr Justice Snowden.
I hadn't thought of that.
Now Lord Justice Snowden,
Yes, I hadn't
but
thought of
he could be forced to return to the
Yes.
business and property courts.
My goodness, I'm not sure he would thank us for that. I hadn't thought of that. Yes. Now I remember, I think Lord Justice Hoffman did that once in a reported case.
I suspect lots of people.
There are plenty of
Right.
examples of people who've gone up, coming back to sit in their old jurisdiction.
My point, ground 6 raises a short but very important point. My Lords, when we appeared before Mrs Justice Falk on the 5th of March, we were told that we did not have standing. Our application for recognition was pending. We asked for the application before her for permission to create a charge in favour of Mishcon Daria to be adjourned and heard together with the recognition application. Unfortunately, Mrs Justice Falk proceeded to make the order and gave us permission to apply to set it aside should we obtain recognition, which of course we have obtained. What the judge has overlooked, with great respect to him, and this is the discrete ground of appeal in ground 6, is that we don't need the Immovables Rule at all in order to oppose, i.e. to act defensively, our bankrupt's application for permission to alienate the bankruptcy property. As a matter of standing, we have been recognised and we should be heard, and the Immovables Rule isn't engaged for one moment. And so that, with great respect to Mr Justice Snowden, he was wrong to dismiss the set-aside application because he had no power to assist. It's a non sequitur. We were acting defensively, and the question was, did we have locus? And the answer, according to his own judgment, and subject to this appeal, or my own friend's appeal, is that we are recognised, therefore we have locus, therefore we can defend, and clearly Mrs Justice Falk or any other judge in the court below would take into account the views and submissions of Mr Bedzhamov's trustee in bankruptcy when he wants the court's permission to charge a bankruptcy asset. And so the short point is that he was wrong to dismiss the set-aside application on grounds that he had no power to assist. One might call that the defensive, not offensive point. The Immovables Rule was never engaged. And now, my lords, that leaves the merits of that application to set aside. And I recognise that in this court, it is likely that you are either with or against us on that submission that I have just made, so far as ground 6 is concerned. If you are with us, that it was a non sequitur, and that he couldn't dismiss the application because we were acting defensively, you don't need to know about the merits. If you're against us, you don't need to know about the merits. I hope it's sufficient for me to say that possibly in an overlong way, we have set out what we regard to be the material merits in our skeleton argument. And if and insofar as they become controversial or engaged during the Learned Friends submissions, perhaps I can deal with those in reply.
You've kept very well to time, Mr Davis.
I'm not always. I don't know whether your lordships have any more points that you'd like to ask me in terms of the opening of my appeal.
Let me just check. No, we don't.
Very much obliged.
In which case, let's stop there and we'll come back at 2 o'clock.